How are you going?
Well, there's lots happening.
So there's a lot going on in
Yes.
relation to penalty rates, and
Yes.
we've had the legislation introduced. And this is one of your pet projects because you have a really strong background in the hospitality industry and the penalty rates decisions that have historically been made there. So I know that you're very familiar with the issue. Do you want to just recap why it's back on the agenda, and then we can talk through what this legislation is about and where it might go?
Yes. Now, the whole premise behind the bill is an extension of the government's agenda to protect fundamental rights. And Minister Rishworth has talked about this bill as being to safeguard fundamental entitlements, and she's talked about 2.6 million award-reliant workers in Australia. What it does provide is that, if it goes through in its current form, that is that modern awards, when the Fair Work Commission is looking at the modern awards objective, they will need to ensure that modern awards don't include terms that could substitute penalty rates or overtime where the effect is a reduction overall. So this is typically looking at your rolling up single rates of pay, where the combination of penalty rates, overtime and other provisions in awards has the effect of undervaluing the actual entitlement arising from the penalty rates and modern awards.
This legislation comes against a background of changing attitudes toward the principle behind paying a penalty rate, so Saturdays and Sundays and public holidays, for example, or certain times. We're living in more of a 24/7 lifestyle. Do you think this legislation will impose unnecessary sort of rigour and burdens on what is otherwise a 24/7 kind of society in some respects?
It's a good question. Back in 2014 to 2016, when the AHA was running its case to reduce penalty rates in the hospitality award, a lot of the argument from the business side was the change in dynamics. So yes, we do have unsociable work hours, but we also have a changing society where shops are open a lot longer, restaurants are expected to be available 7 days a week. Society expectations have changed, and that was taken into account by the Fair Work Commission at the time. It comes down to the evidence in terms of making those big changes, but on a day-to-day basis, those penalty rates are there for a reason, and they are enshrined in awards. I think moving forward, because we have seen the retail group apply to reduce penalty rates in the retail award, there's been some discussion in the clerks arena as well. So this legislation, if it passes the way it's looking at the moment, it will mean employers need to be much more rigorous in checking that entitlements are being paid.
I think it's possibly at odds with the way that work has developed around flexibility. Particularly, you mentioned the Clerks Award. It's very constrained in terms of hours of work. That's changing, obviously. People want the flexibility to work around their other family commitments, for example. So a clerk's employee working from home, logging on early in the morning to get a couple of hours of work done, is still going to be captured by the approach to penalty rates. So it seems to me that it's not keeping pace.
It's a really good point that you make, Rebecca, in terms of individual flexibility agreements that might be brought in under the award system to cater to starting earlier or finishing earlier, to cater to flexibility requirements of employees. It's not clear how the non-monetary benefit of an IFA will be impacted by this when you're looking at varying penalty rates, so that someone can start half an hour earlier and they're willing to forgo the penalty rate because it's convenient for them. So that could be an unintended consequence for how an IFA could work moving forward.
What's the business community's general response to this in terms of the submissions that we've heard, or positions that employer groups are taking?
employer associations, the ARA, ACCI have expressed concern with it. Now the committee is actually seeking submissions this week on the bill. We'll probably see a bit more promotion of what those positions are through our normal workplace information channels, but I would expect there'll be a level of concern about the practical impact and the flexibilities being lost
potentially, yeah.
maybe stifled through the bill, which may not be the intention of the bill. And certainly when you read the explanatory memorandum, it's very focused on protecting entitlements. It's not so focused on recognising that flexibilities need to exist and employees actually want flexibilities, such as the IFA that we talked about just before.
Yeah, absolutely. And there are benefits to be gained that don't measure in those financial terms. So remains to be seen, but we'll be keeping an eye on some of the submissions that come from the business community, ACCI and the like.
There's an economic reform roundtable that's being held 19 to 21 August. And that's going to be a discussion about work and productivity in particular. The Greens have expressed an interest in having a seat at the table so they can talk about the 4-day working week proposal that they took to the last election. So it could be interesting because this is all going to happen around the same time. The Senate committee report, the bill going to the Senate and this roundtable in terms of how this bill might look or what might be negotiated in terms of the bill moving forward.
Yeah. Look, it is an interesting convergence of those two issues, you know, in the sense of the entitlements, that notion that there are fundamental entitlements that can never be eroded, and then this review of how people work and how we achieve productivity in a modern and evolving workplace, because they might be, you know, at odds with each other in some respects.
The Greens are talking about a 4-day working week. If we see that happening, how will the 4-day week work with penalty rates against a traditional 5-day-a-week based award, so that if the Clerks Award, for example, moves to the 4-day working week, those penalty rates need to be flexible to meet the flexibility of 4 days.
Exactly, to be traded off against compressed working hours.
Yes.
Exactly. You know, again, it really just adds to the tension between the move towards flexibility, the move towards alternative ways of structuring how work is performed and when it's performed.
Yes.
And this notion that penalty rates need to be protected because they go directly to when work is performed. And that's going to be a fundamental tenet of flexibility, which is clearly something that is not going away and a direction that modern work is moving very quickly towards.
Yes.
All right. Well, there'll be much to watch with interest, and we'll tune in again, I think, in another week, Jo, and recap some of the developments since then.
Yes.
Thanks.
Thanks, Rebecca.